How are attorney fees paid? Well, typically in the state of Indiana, attorney fees are typically paid on a contingent fee basis. That is, the fee for the attorney is contingent upon the recovery, whether the recovery is by a settlement or whether the recovery actually comes from a jury verdict that becomes a judgment. There are two types of contingent fees. Both of these contingent fee agreements typically have the standard language in them that says that the attorney will be paid based upon a recovery or settlement, whether the settlement is by out-of-court settlement or by in-court from a jury verdict. There is, number one, a flat fee schedule. That is a percentage such as a typical 1/3 standard fee agreement, where the attorney is paid 1/3 of the gross recovery, whether it is by settlement, whether it is by settlement after a lawsuit is filed, whether it is by a jury verdict that becomes an actual judgment that is awarded. The 1/3 fee stays the same from the beginning to the end. The second type of fee agreement is an increasing percentage fee agreement. This increasing percentage fee agreement typically provides that the attorney may, for example, receive a 1/3 fee if the case settles. However, if you file suit, that is, if you have the attorney file a lawsuit because it can't be settled or you're unwilling to accept the offer made by the insurance company, then the percentage typically will increase to 40%. Some attorneys increase the percentage of 40% at the time you file a lawsuit. Others will increase it at the time you go to mediation and perhaps settle the case during litigation. Others may increase the fee to 40% at trial, where there's a judgment awarded. Some even increase it to as high as 45% if you take the case to trial and are awarded a verdict which becomes a judgment. Blackburn and Green's policy has always been from day one. A flat fee schedule will be offered to the clients. It is a standard 1/3 fee agreement of the gross recovery. The policy of Blackburn and Green is that we advance all pre-litigation expenses. If a case doesn't settle and we have to file suit, we'll sit down and discuss with the client what the typical costs are and whether or not those are going to be advanced or not. That's something that we'll discuss in detail with clients so that there's no misunderstanding whatsoever. It's important to understand that all cases involve incurring expenses for typically trying to settle them or to go to trial. Examples would be to obtain medical records and reports. Doctors and hospitals may charge $10 to $15 for copying charges. You may also have doctors write reports. They may charge as much as $100, $150, $200 or more if you ask for a complete report for your prognosis of your client or an impairment rating or disability or chronic versus permanent pain. It's not unusual that there'll be investigation expenses. Filing fees to the court can be $146 or more, depending on how many defendants you name in the lawsuit. Doctors charge, they're also court reporter and other expenses. Many attorneys offer the clients the advantage of prepaying these for the client. That is, attorneys will advance the expenses for the client. The ethics rules, that is the professional rules of conduct in Indiana, allow attorneys to advance expenses for clients. That's helpful to clients because they don't have to come up with a retainer to help cover the expenses. However, it's important to recognize that attorneys are not ethically allowed to give money to clients for their case, nor are they allowed to make a loan to clients. We are simply allowed to advance expenses to clients to help them with their case and to prepare it. An attorney should never promise or guarantee what the exact result will be in your case. At an initial meeting of client, there would not be sufficient information for an attorney to make an evaluation as to what could or could not be received on your case. It's important that no attorney make a promise or guarantee to you. In fact, in our attorney fee agreement, we actually put in there that we do not make a promise or guarantee. We need to do a good job of getting the documentation, supporting your claim and knowing what the doctors will say, get all the medical bills, medical records, lost wages, whether there's an impairment rating, whether it's going to be a temporary injury versus a permanent injury with pain or impairment. Those are all factors that are not known at a first meeting, and it should not be discussed with a client as to what a guarantee would be. An attorney just simply cannot do that. That would be unethical in the state of Indiana. It's also important that you receive a copy of the written agreement after you approve it and the attorney assigns it. You should have a copy for your records and for your file. One last point on attorney fees is this. Although we have a standard fee agreement of 1/3, which is a flat fee of the gross recovery, it's always been the policy at Blackburn and Green that your net take-home part of the settlement will be greater than Blackburn and Green's fee. If in fact that does not occur because of problems in the case, whether it's a question of fault or whether it's a question of bills maybe not necessarily being related to the injury, it's been our policy from day one that we'll reduce our fee so that the client, so that you will receive more than Blackburn and Green's fee.